Okay, so imagine your insurance buys you a brand new phone after someone bumps into you on the street and shatters yours.
Right, yeah.
And then you turn around, sue the person who bumped into you for the cost of the phone, win, and you just keep both payouts. Two phones, one broken screen.
Which is a pretty great deal for you, but yeah, not exactly how the law works.
Exactly. And that is the core issue we are looking at today. Welcome to this deep dive. We are looking at a 2017 California case, Duncan v. Wal-Mart. Our mission today is to explore exactly how the law prevents you from getting paid twice for the same injury.
Yeah, and also this incredibly clever courtroom trick that, well, it almost upended that entire system.
Right. So to really understand this trick, we need to talk about what is basically the grand bargain of workers' compensation.
Yeah, the grand bargain.
Yeah.
So if you get hurt on the job, you get these guaranteed benefits. Medical care, lost wages, things like that.
And you don't even have to prove the employer was at fault, right?
Exactly. You never have to prove fault. It is this vital, immediate safety net. But say a third party caused your injury, like maybe you were working on someone else's property, say a Walmart.
Right, which happens all the time.
It does, yeah. In that case, you still completely retain the right to sue that third party in civil court.
Okay, so if that is the grand bargain, I mean, the insurer pays up front, but you can still sue the third party later. How does the system prevent that double payout, that two phones situation?
Well, the law gives your employer or, their insurance company a first lien. They get to reimburse themselves for the workers' comp benefits they paid you.
Oh, I see.
Yeah, and they just take it straight out of your civil lawsuit winnings.
Which naturally opens the door for someone to try and, completely bypass that rule.
Oh, absolutely. People definitely try.
And that is exactly what happened here. So Denise Duncan was injured while working on the premises of a Walmart. Her workers' comp insurer stepped up and paid out over $152,000 in benefits. And about $37,000 of that was specifically temporary disability indemnity, which is basically a replacement for her lost wages.
Yeah, wage replacement.
So she then sues Walmart for negligence, and she actually wins a $355,000 judgment. But she did something highly, highly strategic at trial.
She did, yeah. It was very clever. She sued for medical expenses and pain and suffering, but she specifically withheld any evidence for those lost wages.
Wait, really? She just didn't bring it up at all?
Exactly. Because she didn't ask the judge for lost wages, her $355,000 award didn't include a single dime categorized as wage replacement.
Okay, so she turns around and tells the workers, comp insurer, they can't have their $37,000 for lost wages back from her settlement.
Right. Her argument is basically, well, I didn't win any lost wages from Walmart, so if that specific bucket is empty, you can't take from it. No double recovery.
I mean, I have to admit, logically, that sounds pretty airtight.
It really does sound clever, but the appellate court completely rejected it.
They didn't buy it.
Not at all. They called it the matching theory fallacy. Basically, the court views the injury as one single event. You didn't have a lost wages injury and then a completely separate pain and suffering injury.
Right. You just had the one accident.
Exactly. Just one accident.
Yeah.
Therefore, all compensation from that accident goes into one giant pot.
Okay, so it all goes in the pot.
Yeah. And the insurer gets to take their statutory share right off the top before you can even divide the rest up.
So you can't bake a $355,000 pie, claim none of the slices are lost wages flavor, and then tell the insurer they can't have a slice.
That is a great way to put it. Yeah, the law says the insurer has a claim to the whole pie, regardless of how you try to slice it.
Wait, so if I do all the heavy lifting, like hire the lawyers, fight Walmart in court for years, build the pie, the insurer can just swoop in at the 11th hour and take my winnings without lifting a finger.
Well, not without paying a toll. That brings in something called the common fund doctrine.
The common fund doctrine. Okay, right. What is that?
So if the insurance company is just sitting back passively, letting you and your lawyer do all the work to win that settlement, they are legally required to pay a reasonable share of your attorney fees.
Oh, okay. So they can't just get a totally free ride on your legal battle.
Exactly. In Duncan's case, she had a $63,000 legal bill. So the insurer's lien was actually subject to a deduction to help cover their fair share of those costs.
So the ultimate takeaway from this ruling, I mean, it really secures the workers' comp system's solvency, right?
It absolutely does. By shutting down that matching theory loophole, it ensures that tactical courtroom maneuvers can't just leave insurers holding the bag.
Right, which sets the absolute ground rules for how practically every injury settlement in the state is negotiated. The statutory lien protects the grand bargain.
It does. It keeps the whole system functioning.
It makes you wonder, though, if the insurer's lien is absolute and comes out of that giant pot first, what happens if a third-party settlement is so small that it only covers your lawyer's fees and the employer's reimbursement lien?
Yeah, that is a really tough scenario.
Right. We have built a system that protects the grand bargain, but it might theoretically leave a permanently injured worker with exactly $0 for their actual pain and suffering.
It is definitely a harsh reality of how the math works out sometimes.
Yeah, definitely something to chew on next time you see the gears of the legal system churning. Thanks for joining us on this deep dive. We will catch you on the next one.